welcome. Shoot your questions. I'll be here for 15 minutes answering all your immigration and business immigration and entrepreneurship questions. All right. So let's start with the first one. This is from Peculiar Sagi. Hi, would you call someone spending 5 months overstay if they gave you 6 months? So basically what this person is asking is if someone entered the country on a visa and the visa, the I-94 allows them to stay 6 months and they stayed 5 months, would that be considered? And if the person stayed in the country beyond the 6 months or beyond the time that they were given, then they would begin to accrue unlawful status. So no. And I know one issue with this, like a lot of people always ask, well, if I enter the country and I stay for 5 months or I stay right at 6 months, is that something to do? No, it's not. But what you don't want to do, say you spend 6 months in the country and then you return again in the same calendar year, immigration is going to look at that like you're spending more time. Just make sure that when you're spending those long periods of time, you have valid reasons and you have proof of it. So if you stayed 6 months and you're there visiting someone that's sick, or you're there doing tourism activities such as visiting Disney or doing those type of things, make sure you have the proof of that for when you're trying to re-enter the country again. But it is definitely not advised unless it's absolutely necessary to spend more than 6 months in the US back to back, unless you have proof or you can actually corroborate that. Do I have an office in Melbourne, Florida? No, I do not. But you can always call and we can do a Zoom or virtual meeting. And there's also an office in Fort Lauderdale that you can visit also. Wagwan, yummy honey, Modern. If my case is still pending and my husband divorced me, what are the plans? So I'm assuming, and this is from our TV, is okay. So they're asking if you got married, right, and you filed, I'm assuming, an adjustment of status. While the case is pending, your partner then divorces you. What are your options? Well, typically in a case like this, it depends on the reason why you got divorced. Then you may be qualified for a VAWA self-petition application. So what would need to happen is you would need to come up with the basis of the abuse that took place in that marriage. So abuse doesn't have to be physical, it can be verbal, it can be psychological, it can be financial. But once you qualify for VAWA, you are now able to file a self-petition where you're not dependent on that marriage as the basis for your adjustment of status. Yes, big up Jamaica College. All right, so if you have a conditional removal that's not as been taken off, could you apply for your citizenship? So I believe this is the same person that asked me if your case is still pending and there's a divorce, yeah, you can file for your citizenship. But the thing is, once you have an I-751 pending and you apply for your citizenship, when you do get that interview, they're still going to make a decision on that I-751. And if you didn't meet the burden to get that I-751 approved, then they will deny the citizenship anyway. So this is definitely something that you want to schedule a consultation for. Good day, my future immigration lawyer. Yes, good day, my future client. All right. Hey, good day. Hope you all are having a great day. Yes, we are. My question is, can your son's wife petition for his mother? I doubt that. So you're asking if your son's wife can petition for the mother. No, you'll have to wait until your son has become a green card holder. No, actually, your son has to become a U.S. citizen before he can petition for your mother, for his mother. All right, let's take some TikTok questions.
Yes. So I have, hello, I'm your number one fan.
Hello, number one fan.
My husband removed his condition and he's been waiting on his green card for almost 2 years now.
Okay.
What can he do?
Well, if he's been waiting almost 2 years for his removal of conditions, that's not abnormal. More than likely, he would have gotten an extension for either 18 months or for 24 months. So that's just something that you'll have to wait, because they are backed up with that type of processing. But what you can do is, since you guys are still married, once it hits the 3-year mark, or 3 months before the 3-year mark of him having that conditional green card, he can go ahead and file for his citizenship, right? And now would be a really, really good time to do it, since it is an election year. They would schedule that naturalization interview, and in that interview, they would make a determination on the I-751 and if he has qualified for the N-400 as well. All right, so definitely seek a consultation for that, because he can be in a better situation.
Okay, next one. I need to know about the diversity visa.
Okay, so the diversity visa, that is a lottery. So it's based on your country. You are able to file basically for a green card or lottery, meaning if your country is eligible, they open up that lottery period and they just randomly pick someone to get a green card.
Okay. When USCIS RFE, what usually happens after they receive it? How long do they take to make conclusions?
Okay, so the question is, what's an RFE and how long does it take? So an RFE is a request for evidence. So you get a request for evidence once you have submitted some type of immigration petition or some type of immigration application, and the officer needs further evidence to make a determination on your file. Once you submit that information, your case goes back into its regular processing, and they will either make a decision on your case, or sometimes do another request for evidence if you haven't satisfied it. So sometimes they approve the case, deny the case, or they send another RFE.
I have a bachelor's in chemistry and a bachelor's in pharmacy. Can I file NIW?
Based on that information only, you may have a strong possibility for that, but that's something that we would need to look at your resume, know your background, and then make a determination if you'd be eligible for an EB2 NIW, which is a national interest waiver. Because we're still going to have to prove that you are at the top of your class, you are in the top of your field, and whatever initiative or endeavor that you are coming to the US to do, it will have high impact. So that's something that we would need to analyze further, but based on those degrees and qualifications, you may be eligible, but we need to know more.
Can a 2-year green card holder file for their 19-year-old child?
Can a conditional green card holder file for their 19-year-old child? Just based on best practices, I would definitely wait. Like if that child was, well, no, they're an adult. If they were not added before, hold on. So best practices, if that child was not added to the petition before, it's a little bit challenged now since you are on a conditional green card. I would wait until I get that conditional, until I get the conditions removed, or I would have my spouse, the spouse that you are married to, file that petition for them as a step parent. However, you would have needed to have gotten married before that child turned 18. All right, so the short answer is, for you to do the petition, I would wait, but if it's your US citizen spouse, yes, they can do it if you got married before that child turned 18.
Can my sister, who is a U.S. citizen, adopt my 16-year-old who has no status in the U.S.?
Yes, your sister can definitely. So the question is, can a sibling that's a U.S. citizen adopt a minor child that is undocumented? And the answer is yes. However, there are steps to go through before that can happen. The first step is you will have to go through the legal adoption process to where you are now giving up your parental rights, and your sister will be the legal adoptive parent. Once they become the legal adoptive parent, and if they're still a minor, yes, she can do a petition for that child.
Perfect.
All right, do we have any
Yes.
questions on?
We got 2 on YouTube.
Okay. All right, so YouTube questions.
Yes. So Alicia says, "Hi, thanks for being live again.
No problem.
How can I return to the US after overstaying over 150 days? I have 2 US citizen children."
Okay, so you have 2 U.S. citizen children and you have overstayed by 100+ days. Um, it's going to be challenging. It's going to be challenging from just a visitor's visa standpoint. A visitor's visa standpoint, you can always reapply, but usually once there's an overstay, which you would need to have evidence of the reason why you overstayed. Usually the only thing that they would even entertain is if it was a medical reason. But outside of that, yes, you can apply and do a waiver, but the approval rate for that is less than 50%. Chances are you'd have to wait until those children turn 21, or you'll just have to wait for some time to pass and strengthen your ties to your home country and try to reapply. But unfortunately, I haven't seen positive cases where a visitor's visa is being reinstated after an overstay.
Okay. Next one says, "Can a F1 student who is out of status regain back their status?"
An F1 student that is out of status, it is very, very difficult. So the question is, can an F1 student, meaning the person that's on a student visa, they became out of status and they're trying to get back in status? So the only time I've seen that works is if they have filed. So back to the question. So the question was, can an F1 student who has lost their status get reinstated? Right? The only time I've seen that work is if the sorry people. Hey, can you go ask if Daniela is still here? Because she's trying to call me and tell her I'm doing a live. Sorry about that, folks. All right, so for the student visa, it only works if you went out of status because you were waiting to get into another school and something fell apart, like either it's an OPT or something with the application period. That's the only time I've seen an F1 get reinstated by another school. If for some reason you are out of status for like almost a year, it's not possible for that F1 to get reinstated. You'd have to find another means to get back legal status, which would involve an adjustment of status through an immediate relative, or you'd have to leave the country, file a waiver, and return to the country once that waiver is approved.
Okay. This one is from Teresa. "Thanks for being live. If a U.S. citizen's son petitions for his parents, after the parents receive their green card, how long after can they petition for their other kids? Also, if one child is married."
Okay, so basically a U.S. citizen child petitioned for their parents, right? The parents then got their green cards. So the person wants to know, after getting the green cards, their parents, how long after can those parents now petition for their other child?
Yes.
So as green card holders, they can petition at any time, and they would just have to go through the process of either NVC if they're in the country or outside the country, but they can petition at any time. If the child is over 21 and unmarried, well, they would be, I believe, an F3 category, which there's a long wait time. If they are married and over 21, it's even a longer wait time. If they are under 18, it's a short wait time. So the short answer is you can petition at any time.
Okay. Marlon says, question for you from out of Toronto, Canada. My wife's father is a U.S. citizen and wants to file for her. But why does it take so long for her to get her green card being a Canadian citizen?
Okay. Yeah, so unfortunately, right? So the National Visa Center, right? You have to go through consular processing if you have a U.S. citizen or a green card holder petitioning for a family member that is outside of the country.